All right. Well, good morning, everybody. It is Sunday morning here, March 23rd, and there is just a lot going on with the Karen Reed case. And as we get closer and closer to trial, we can assume that more and more things are going to heat up. But we definitely had some very interesting hearings last week, or a hearing last week, which covered a lot of motions. We spoke a lot about the motions. I want to circle back, and talk about some of the issues that came up in last week's hearing. As well as take some questions, because I know, especially from the last motion about getting the text messages from David Yannetti, between David Yannetti and Karen Reed, there's been a lot of questions, a lot of speculation, a lot of discussion. So I did do a video on it. If you haven't seen that, definitely go check that out, where we talk about some of the law. So we'll revisit that issue also. But I did get some questions that I want to get into first, and then we'll try to take each issue one at a time. If you have questions, definitely put them in the chat. Put the question marks before them so I can tell that they are questions. And hopefully we'll be able to get to a lot of questions today. Just first off, did get a question right away in the chat here from Lindsay Bowe. But Brother Counsel, did you see the Diddy case from Michigan? This obviously, excuse me, does not have much to do with the Karen Reed case. But the Diddy case from Michigan, Diddy had a guy put in prison. Detroit judges, police, DA, and prosecutors all paid off. Like, there are affidavits from the people paid off. So I'm not entirely familiar what's going on with that case. I am keeping an eye a little bit on what's going on with the Diddy stuff. But like a lot of the court hearings are not live streams. We're not able to actually see what's going on in courts. We have to rely a lot on reporters and people that are in the courtroom, and it's not the best way to go about it, which I like to see things actually going on in court. So I don't have much to say about the Diddy stuff, but really we're here to discuss Karen Reed. So again, if you have questions, definitely put them in the chat. I'll try to get to them as we go through the different issues that we have to cover today and discuss today. So here we go. Here's the first question that I got. Did I hear Judge Cannoni correctly that jury selection is expected to take a long time, and she probably won't be swearing them in until April 25th? Anyway, as the rationale for not allowing the motion to continue the trial. So did you hear Judge Cannoni correct? Yes, I think you did hear Judge Cannoni correctly, that jury selection is expected to take a long time. I don't remember how long it took last time. If somebody remembers, you can put it in the chat. But there's been a lot more publicity since the first trial. So there's going to be a lot more people that know about the case, and they're going to have to flesh that out during jury selection. There's also a time constraint. This trial should go on for a while, so you can expect that can be a hardship for some people, and therefore, okay, I see in the chat it took 2 weeks last time. So if last time it took 2 weeks, I think it's not unreasonable to assume it's going to take longer this time, especially given the publicity that we've that this case has taken on. So it's not crazy to think that it might take till April 25th. Now, personally, like you all know already, April 25th is actually better for me. So, we can't see what's going on during jury selection. So I'm just going to be in a waiting pattern and hearing from different reports or reporters or journalists that are in the courtroom and tweeting out what's going on. If it does take till April 25th, that's great for me personally, because I got a Jewish holiday starting right between April 1st and April 25th. So personally, it would be better for me because April 25th is when it's over. So I'm not against that at all. But you did hear correctly that it could take that long, even though it seems from Judge Cannoni that there is not going to be lawyer to juror directly questions. There's not going to be questions directly from a lawyer to a juror. Everything's going to be, seems like, from the judge. And if you have issues, if you want to ask questions to follow up, you're going to have to go to sidebar and ask the Judge Cannoni, to ask those follow-up questions to the specific jurors. So therefore, it's not going to be as exciting. As you know, I love to see jury selection. I always like to see how attorneys approach it. But it seems that that's not going to be so exciting in this case, at least, because we're going to have the judge really asking all the questions. So that's in terms of that. It may take that time. Next, what was going on during the joint hearing with Aidan Carney? And one thing that is interesting is that everyone says his name differently. You've got Carney, you got Kearney, but I believe that it is Carney, so I'm going to try to keep to Carney. So what was going on during the joint hearing with Aiden Carney? I know why Brennan was there. Why did Karen and her attorneys come in late, if you would hazard a guess? I'm wondering if there is something unethical going on with Brennan or if there is a reasonable explanation. So generally speaking, this is something that I was wondering as this is going on. Generally speaking, when you have a Rule 17 motion, this was a Rule 17 motion where they're requesting, Brennan was requesting to get this information from Karen Reed, right? He wants these text messages between Karen Reed and Turtle Boy. So the third parties could be present, should be present, and therefore Karen Reed's attorneys could definitely have a basis to be there. That's why they showed up. It has to do with Karen Reed, and therefore she should have a voice in whether her text messages get disclosed or not. So that's why the attorney showed up. It seemed that there was a little surprise there from Hank Brennan, although I think the live started a little bit late, so we couldn't see the full extent of it. But that's why they were there. Brennan didn't want them there, and there was some discussion about them, whether they can actually have standing to even challenge this request by Hank Brennan. So the judge did allow Karen Reed's attorneys to speak. He allowed them to stay at the table, like if that makes a difference to actually sit at the table or sit behind the table. But they did argue why Lampron wasn't satisfied. That was Elizabeth Little's argument there that Hank Brennan didn't satisfy Lampron, which is the case which governs these third-party communications or other materials that you want to obtain in this case. And eventually we know that order came out and it was granted in part, and they are going to get some of those text messages. So we're going to see exactly the extent of what Karen Reed knew about any sort of witness intimidation or anything that Turtle Boy was doing, whether it was his own decision, whether it was directed by Karen Reed in any way, or whether it was encouraged by Karen Reed in any way. So that's something that we're going to be seeing most likely from those text messages. So he did grant that, or in Massachusetts they call it allow it in part. So he did allow it in part. So we'll be seeing about that. Continuing. I read a comment on X, not the most reliable source, but it was written by an attorney, Richard D. Vedstein, that Massachusetts has not formally adopted the codified rules of evidence you cite. This was in response to a post of Andrea Burkhart about the motion to obtain the communications between Karen and Yannetti, citing Massachusetts Rule Evidence 523. So let me pull this up for you, because this was the tweet. Andrea Burkhart put out a tweet about, I'm always willing to entertain legal debate. I have cited Massachusetts Rule of Evidence 523b1, in which the standard for waiving privilege is not knowing and intelligent, but rather voluntary, that derives from these cases which set out the black letter common law rule. So this is what this attorney responded, Richard Vedstein. He retired two responses. One, a former Massachusetts judge at the Carol Erskine disagrees with your position, as do I. There isn't a knowing and intentional waiver. Plus, even if she talked about one small discussion, doesn't open door to her entire cell phone. Hank can play the tape of the interview. And here's the tweet, which really this question is directed to. A few things here. Massachusetts has not formally adopted the codified rules of evidence you cite. We still go off case law only. And then he goes on to citing about a federal opinion. Now, this idea is another. He's actually true. He's actually correct about this. That for some reason in Massachusetts, again, another oddity in Massachusetts is that they have not codified the Massachusetts rules of evidence. They are a guide. So if you look them up online, you'll see the entire rules of evidence and their guides, but they were put together by a committee by the Supreme Judicial Court of Massachusetts to put together those rules of evidence for attorneys that are practicing so that they can reference very easily the rules. Now, it's just a question of really, okay, they don't have the same bite as rule of evidence that's codified, but they're all based on case law. So if you look at the notes of all those rules of evidence, they are all based on the case law in Massachusetts about those specific rules of evidence. So yes, technically, if you just cite the rule itself without citing the case law that backs that up or is the basis for that rule, so then yeah, it's technically not something that's as persuasive as it would be if they were codified. But nevertheless, this is from a committee that was put together by the Supreme Judicial Court. It was okayed by the Supreme Judicial Court, and therefore they're all based on case law. So it really is still a very strong position to quote from those rules of evidence, and since definitely that they're based on the case law. But technically speaking, he is correct about that specific issue. So That's just another oddity that you have in Massachusetts case law or Massachusetts law. Now, let's get into a little bit about these text messages with Yannetti. And we spoke about this in our last video about whether there is an attorney-client privilege and whether that client privilege was waived. So I want to pull up one of the cases. Let me just see if I can. Okay, let's start with this case, and then we'll just move on a little bit just to get a little bit of an understanding about the case law as it relates to disclosing attorney-client privilege or communications. Give me just 1 second to pull it up here. Okay, this is what we have. So this is the case that I cited to when I was talking about in the video that I did in last week on Friday, and this is what it says there. Disclosing attorney-client communications to a third party, including an accountant, generally undermines the privilege. Okay, so if you are having a conversation with somebody else present in the room, then that communications that you're talking about is not privileged anymore. So the attorney-client privilege is broken when there's a third party there, unless that person is just there to facilitate communications between the attorney and the client, which obviously was not happening with Gretchen Voss. They didn't need Gretchen Voss to help them communicate with each other, to help them understand anything. So any communications that Karen Reed had with Gretchen Voss, in which she talks about certain communications that she had with David Yannetti, so then definitely there's a strong argument that those communications are waived. But the question here, which I stressed in my video on Friday, the question here is not just simply, okay, does that mean that now that she spoke about certain communications that she had with David Yannetti, does that automatically mean that all communications that she had, all emails, all text messages, anything that she ever spoke to about David Yannetti in those 3 days or 4 days that Hank Brennan is asking for, does that mean that that is not privileged anymore either? That's the question that I stressed has to still be answered. And again, I'll also stress the fact that Hank Brennan did not provide this authority. When you're asking the court to do something, you have to provide authority. If you don't provide authority, so then the judge can just look at you, and especially if you're the other side, in your responsive papers, you should say, Your Honor, he's making an interesting argument, but he just hasn't provided any authority, and that's what you have to do. So he hasn't really provided much authority at all. All Hank Brennan cited to in his motion was that there are definitely a waiver that could be there's these communications could be waived. The privilege could be waived by the client and not the attorney. So that he did mention, and he cited a case to that effect as well. But that's the extent really of his authority that he provided to the court. He didn't provide any sort of analysis of why this specific communications with Gretchen Voss constitutes a waiver, and he didn't also explain the scope. He's looking to obtain all these communications, all these emails over that 3-day period. He hasn't really explained or provided any authority. I mean, I provided more authority than he did when just looking up this case that allows the discovery of these communications. So that was just one problem with his motion. But let's just move on anyway, because we'll talk about the idea of this waiver. So there's another case here. Let me just make sure this is the right case here. Oh, that's something else. Here. Okay, this is where it gets more into the law about what exactly is considered waived. Okay, so here, this is a case, Clare versus Clare. And they're talking about another case, Darius. So we opined in Darius that the scope of an at-issue waiver, okay, this is what it's referred to, an at-issue waiver, is not to be viewed too broadly. So here, the question here is that, okay, what is the scope of what exactly is waived? When you just say, my attorney said this, and I responded in the following way, what exactly have you waived? So what you've waived is something called at issue. Whatever the issue is specifically that you're talking about with this third party and this communication with you and your attorney, then it's an at issue waiver. So whatever the issue was you're discussing, that may be waived. But it can't be viewed too broadly, and it can't be too broad. When it is recognized in particular circumstances, an at issue waiver should not be tantamount to a blanket waiver of the entire attorney-client privilege in the case. By definition, it is a limited waiver of the privilege with respect to what has been put at issue. And they continue here. So, okay, and then they say here, in addition, there can be no at issue waiver unless it is shown that the privileged information sought to be discovered is not available from any other source. Okay, so this is probably true also in this case, that they don't have any other source. Hank Brennan has no other source to get these communications between Karen Reed and David Yannetti. So that part maybe also be satisfied. Again, he hasn't quoted any of these cases. So it's still a decent argument to be made by the defense that there may be cases out there or law that exists, but he hasn't done his homework. Okay, so then the question is, okay, so the at issue waiver. So technically speaking, the argument can be that anything that you spoke about with David Yannetti about the issue of this specific conversation about whether she clipped him or ran over his foot, or the other things that she said that she spoke to David Yannetti about. Okay, so maybe that's an at issue waiver, and then therefore text messages or emails that have to do with that specific issue could possibly be waived. But however, I will say also that from my research, most of the cases that I found that talk about at issue waivers are mostly limited to issues that are brought up in front of the court. This is something that a client will bring to the attention of the court. So this is where you want to bring up a certain issue in front of the court, and then you want to assert your attorney-client privilege for any other communications. So this is where the idea is you can't use it as a sword and a shield at the same time. You can't say, well, I'm only going to disclose certain parts of the communication and then stop it as soon as I want to and then assert my attorney-client privilege. You can't do that. Once you opened up the door, as we all heard about that, once you open up the door, so then the door's open. And that issue can be explored, and any communications should also be revealed. So, but again, most of the time that I've found from these cases, it's usually an issue that is brought up in front of the court. It's not an issue that is in a separate communication with a blogger or a separate communication with a journalist. So that's still, if you really want to do this right, you got to find the cases that talk about specifically an out-of-court statement that was made that talks about attorney-client communications. And then at that point, the court allowed those communications to be discovered and what the extent is, what the scope was. So that still has yet to be seen. We haven't seen any sort of argument about that yet. Again, sometimes Hank Brennan gets up there and starts arguing other things, and maybe we'll cite other law. And then at that point, we'll have to see how the court deals with it and how Jackson deals with it, or the defense deals with it. I think a reasonable response in that situation is if Hank Brennan does get up, like we've seen in the past, where Hank Brennan will get up and will say some additional things that he did not include in his papers. What the defense definitely could do, which I've done in the past, is, Your Honor, he's bringing up new arguments now. He's citing to new law. I had no chance or opportunity to do some research about the law that he's talking about, other than taking his word for it. So the at the very least, what the court should do is not rule on this and give us some time to respond and do some research and see whether the cases that he's citing is actually on point or not. So that definitely could be a response if Hank Brennan decides to bring up these arguments or do some more research, probably this Tuesday, right? That the next hearing is going to be this Tuesday. So that is in terms of the attorney-client communication or privilege. So let me have to go back and see if I got any questions here, because I was just talking a little bit. So give me a second here as I scroll through and find the questions. I'm going to try to look for the questions that specifically have to do with the privilege. And if not, we'll just move on. Here's a question, Brooklyn. If your client wanted to do an interview before second trial, would you allow it, and why did she do it? In regards to Brennan asking for private conversations, I believe that's allowed because Karen opened the door. And that's kind of what we were talking about. If my client wanted to do an interview, no. I mean, every attorney is going to tell you not to allow your client to do interviews. In this case, obviously, they're doing things very differently. Again, also, I think people don't know exactly when all these documentaries were recorded and when they signed the papers that they're allowing them to disseminate them. So, question is, did they think that they were going to win the trial, and that's why they did these interviews, and now they're already stuck because now it came down with a mistrial, and now they're stuck with the original contract that they had with this docuseries or whatever it is. So obviously, any attorney is going to tell you they don't want their client talking to the press at all. They don't want their client opening up their mouth at all. But in this case, it's different because they keep saying they have nothing to hide. Nothing to hide. Go ahead and talk. But it's never a good idea because prosecution can always take some of your statements and try to use them in a way that makes you look guilty. This is exactly what's going on here. Here's a question. Patty B, did you ever go up against a lawyer like Hank? What do you think of his sneaky tactics? You always have attorneys that try to one-up you all the time. And a lot of times beforehand, everyone's going to be one way sometimes, and it seems like they're good guys, and they're not going to try to spring something on you. And sometimes they do. And sometimes you get the reputation, and everyone therefore has their antennas up. I mean, we have in Michigan, we have, some groups of attorneys. I definitely, on my side, I do a lot of civil work now. So we have our own group, and we already can talk to each other about other attorneys and what they're like to deal with during trial. So we know pretty well going into the trial or going into any sort of court hearing with opposing counsel, if they do these type of tactics, if they try to, sneak in things or tell you one thing and then argue to the court something else. So yeah, you definitely get all types of attorneys, and you got to be ready for it. So these are, again, I don't think anything's surprising. Alan Jackson or David Unetti, all these attorneys are extremely well experienced, and they know how all types of attorneys can act, and they're ready for it. I'm sure they're ready for it. So. Here's a question. Do you remember which hearing he said he handed over all the defense files to the FBI? And do you remember if he said when, last hearing or hearing before? I think it was last hearing when he said that he handed over the entire file. Remember, this is where the problem here is with the ARCA experts, when they got into the argument about these ARCA experts and providing Rule 14 discovery, and also in terms of whether they're able to mention to the jury that they were hired by the federal government. This is going to be a very interesting issue because the defense has pointed out that it can definitely be very prejudicial to Karen Reed if the jury is left speculating about how these ARCA experts got involved in the case. If they got involved by the defense, and the defense then did not turn over certain information, and the prosecution tries to make an argument like that to the jury and say, look, these are the defense attorneys, they hired them, and then refuse to hand over the DNA report or about the hair on the back of Karen Reed's vehicle. And they didn't turn the stuff over, and it looks to the jury like the defense is trying to hide the ball. And that's obviously very prejudicial, and it's speculation. It's actually incorrect. And that's what David Unetti was saying. I think it was pretty sure it was the last hearing where he said when they subpoenaed our file, they asked for the entire file. We gave them the entire file. So why should the jury be left thinking that we did not give them all the information that they needed to come to their conclusions, or that we didn't give them even more information that they didn't need? They should know that we're doing everything that we're supposed to be doing 100%. So this is exactly the problem here, and this is also why some of the jurors speculated that maybe ARCA was hired by the insurance company, by Karen Reed's insurance company, and therefore obviously they're not going to trust or give as much credibility to the ARCA experts if they're hired by an insurance company, because the insurance company wants them to find that Karen Reed did not hit John O'Keefe, and therefore they're not stuck with any sort of liability on that. They don't want any exposure. So that's something that also the jury should not be left to speculate. So that's why they want it very clear to the jury that they were hired by the federal government. Now, the problem with that is that once they hear that they're hired by the federal government, well, then what type of prejudice is that going to work against the Commonwealth? And then Hank Brennan said also that once you're going to open up that door, like we keep hearing about opening up the door, if you're going to open up that door about how the ARC experts came to be involved in this case, well, then, we have to completely and fully explore all communications that happened with the federal government and ARCA, and communications that happened with defense attorneys and Karen Reed, and any sort of investigations that were opened. And he made a suggestion that the whole investigation is only open because there was contact between the defense and the federal government. So that should also all be fair game. Now, this is all going to be, I think, fleshed out at the voir dire. There's going to be a voir dire before they testify. That's what Judge Cannoni decided to do with this. First, they said maybe they'll come back next week, which is this week. But then she changed that to right before. Now, Brennan wasn't so excited by that because it's the middle of a trial, and maybe they're not going to have certain documents, and then they're going to be testifying the next day, and then he's not, he's going to be flying blind. So he didn't really want that. But that seems to be how Judge Cannoni is going to deal with this. That there's going to be an extensive voir dire, just like we had in the first trial, with it not in the presence of the jury, where you'll be able to ask all these questions to ARCA and find out exactly any sort of communications they have with defense counsel, the scope of their work with the federal government, and everything like that. So these are issues that are going to be fleshed out probably at that voir dire. Here's a question by the other Karen. BC, are you concerned the information related to Karen's public interviews will hurt her? And this is obviously the concern of her attorneys, definitely, that anything that you say, even if it's 100% true and it's exculpatory, but a good attorney will be able to try to twist and turn your statements into looking like something that they're not. That's what we're trained to do. That's what we do. We try to get these witnesses to look like they're trying to hide things, or that they're saying things in a certain way, which we are going to start reading into and trying to make arguments that the witness is either not being forthcoming, not being honest, or hiding things, or trying to twist them in a way that makes it look like that they're not, that you shouldn't believe them. So yes, I think that this is a very serious concern. It should be a concern that, even though, and I think this was something that Jackson actually mentioned, is that he's not so concerned with the actual communications themselves. It's what the Commonwealth's going to do with these communications and how they're going to try to present them to the jury in a way that looks like Karen Reed's guilty. So yes, this would be definitely a big concern, which is why you just don't want your client, even if your client is 100% innocent, and you don't want them speaking, because these words can be used against you in the court of law, as we all know. Here's a question. You routinely mention citing authority, but isn't there a first time for everything? Hence, there would be no authority. So is authority always needed? And the answer to this is that, generally speaking, judges from definitely at the trial level, judges don't like creating law. They don't like creating law. They'd rather leave creating law to the appellate courts or to the Supreme Court or to the legislators. So if there is something that does not have strong authority to it, and you're the trial judge, generally speaking, you're not going to just side with that. If there's you can definitely still make the argument. You have a good faith basis for your argument. You can try to make comparisons to some cases that do exist, but just to get up there and say, Your Honor, this just seems that this should be fair. You should do it this way because it just seems fair or right. That's not, generally speaking, that's not going to work in a trial court level, at least. And a lot of times, what the judge is going to do is the judge is going to say, look, there's no authority for me now, so therefore I'm going to deny your motion, and you can appeal me. And if the Court of Appeals decides that there is some sort of law, or they want to decide to create some law, or if it goes up to the Supreme Court and they decide to create some law and look at other jurisdictions to see what they do in certain situations, that's fine. But because I don't have any Massachusetts law that tells me or guides me what I should be doing, I'm just going to punt. I'm not going to create law from the bench. So to answer your question, is there a first time for everything? Of course, there's a first time for a lot of things, but generally at this level, at this trial court level, that's not where they try to create law. So your best shot always is to cite authority, and if you don't, it can really, really be fatal. And there's some really good citations to case law that say that you cannot just create law out of nowhere. And the courts are not your research assistants where you just state the issue in front of the court and ask them to figure out why this makes sense under the law. So it's a very, very strong argument, which I always make. If the other side doesn't cite law or back up their position by citations to any sort of authority, then they've abandoned it. And that's always my position. And it's very, very compelling. And most of the time I win on that. Here's a question from Capnit Trips. And thanks for the donation there. Can I answer the jury questionnaire? I can't recall what, if anything, I've heard about this case. Well, if you can't recall anything, then you can say I can't recall anything. You can say that I did remember seeing something about this case, but I just can't remember specifically what it was. There can be some follow-up on that, but I mean, you can try to play that, but usually, you're going to be asked a lot of questions. You're going to look like you're trying to hide something, and that's not going to be very good, and the judge may not take that very lightly. So here's a question. What if they want the interviews to come into trial so she doesn't have to testify? I'm not sure what you mean she doesn't have to testify. She doesn't have to testify. She never has to testify. And her statements do come in. So a statement by a party opponent does come in. So he can introduce the statements and they can come in. By the way, this is why there's been a lot of discussion about adding the attorneys to the witness list. Okay, so people have been talking about this also. So what does this mean? Adding the attorneys to the witnesses? Does that mean that now they cannot represent Karen Reed if they're witnesses in the case? Obviously, if you're a witness in the case, you can't defend that person if you're going to be called as a witness in that case. So he did put a footnote, I believe, in that witness list, and he said that the reason why he's putting the attorneys on the witness list is simply for authentication purposes, which is just to say that, yeah, this is Karen Reed's statement and this is what she said. Meaning he can't, how do you authenticate that this is actually what Karen Reed said? Right? If you don't have Karen Reed herself testifying that that's me and that's what I said and that's my voice and this wasn't changed or modified or whatever, how do you authenticate it? That's the question that Hank Brennan's thinking about. So he's saying, okay, well, the easy way to authenticate is to ask Alan Jackson, who was there sitting next to Karen Reed when she gave these interviews, or David Yannetti, who was there, or any of the attorneys that were there, that they can authenticate and say that this is actually Karen Reed. So that's why he's putting them on the witness list. For that reason alone, I don't think that therefore they'd be able to make an argument that they're thrown off the case. I don't think this is really anything significant there can be an argument that they cannot represent Karen Reed anymore. Here's a question by Michael DeMarco. Will you be attending the retrial in person here in Massachusetts? No, the answer to that is no. I'm assuming that there's a line out the door in order to get into that courtroom, and exactly it's a small courtroom, and how to actually get in there if you need some sort of credentials from some sort of journalist or whatever it is in order to get in there. I don't have those. Brother Counsel Studios does not have those. And the truth of the matter is I actually enjoy watching the trial with the live stream. So I'm not stuck in the courtroom, and I can take some more notes on my computer, and I can do a lot more stuff here, preparing to recap the trial and to analyze the trial and do some research here. So I find it actually a little bit more comfortable instead of sitting on those benches, on those pews, to sit in my courtroom, sit in my office, as long as I can see everything that's going on. Now, of course, I'm not going to see the jury selection, so that's a problem. But anything that's going on in the courtroom, if we can see it, I'm quite happy seeing it right here. And it's a little bit more convenient for me as well. So I don't have to jump on a plane and leave my practice. I can also get some stuff done here if I have to do a deposition or whatever it is. Certain things I'm doing actually when I'm not watching this trial. So I'm going to hearings on my own cases and doing stuff in my own cases. So I'm able to multitask probably a lot easier when I'm in my office than I am just watching the trial. But I haven't been invited, and I'm not exactly sure how to even get into that courtroom. I'm sure there's a line out the door. So until I see how that can actually play out, I'm going to be happy watching it from my courtroom, from my office. Okay, some of the questions here I see are kind of repetitive, so I'm not going to just pull them up but covering a lot of it with one question. Okay, so there's a lot more questions here, but let me try to move on a little bit more into another area which I want to talk about also. Okay, so we'll try to get some more questions later, but let me there's just one more question we'll get to, because this is from a Captain Trips again. Being serious, how can someone answer the questions truthfully but still be considered for the jury if they follow the case? So what always happens in these high-profile cases is that you get a juror there, and the juror will say, "Yeah, I've been following the case. I've been watching Brother Counsel." So then the follow-up of that will be, "Okay, have you developed any opinions about this case already. And they may say yes or no, or they may say, yeah, I'm just following it casually. I don't really have such an opinion about this case. And especially watching Brother Counsel, he's so objective. So, I'm just really hearing all the evidence in an objective way and the law in an objective way. So I haven't really, come to a strong opinion about the case one way or the other. Most likely you will get a juror. It's definitely within reasonable possibility that you're going to get someone who did hear about this case and was following the case, and just will tell the jury, that tell the court that they haven't really made an opinion about the case. And if they'll say that they have made an opinion about the case, then they may say, okay, well, will you be able to set that opinion aside and just base your opinion about this case specifically in front of us that we're about to try, just based solely on the evidence that you see in court? So again, that's really what it all comes down to. Can you make a determination and ignore everything that you've heard before, ignore all the social media, all the reports? Is it possible for you to put all that aside and to be able to consider everything fresh and give everybody a fair shot in this trial? Can you do that? And if someone can answer, yes, I can do that, well, then he's not going to be struck for cause. They can choose to dismiss him with a preemptory challenge, but to excuse that person for cause is as long as the person says that, no, I can completely be fair to both sides in this case and just base my verdict solely on the evidence that's presented in court, well, then that person should be able to sit as a juror, whether they're saying the truth or not. Okay, so let's move on a little bit more. I want to talk about the manner of death, because this was an interesting issue that came up in the last hearing. They're talking about whether the manner of death should be taken off of the death certificate. And like I said, there's some pretty strong case law when we spoke about this in our last video. It wasn't the last one, whatever. A few videos ago, where there's some strong case law that says that the manner of death should be taken off of the death certificate. And Elizabeth Little made a very interesting and compelling argument. Her argument was that all those cases that discuss taking off, redacting the manner of death from the death certificate is when the manner of death is determined to be an accident, determined to be a homicide. But there's no case that she found where it says that if the manner of death has been undetermined, that also comes off the death certificate. Now, just thinking about this logically, you can understand her argument, because the reason why you don't want homicide listed as the manner of death on the death certificate is because you're kind of telling the jury that this is what the finding was, that it was a homicide. And therefore, that leans very, very strong, is very prejudicial against the defendant, that there's already been a determination in this case that this was a homicide. And if your defense is that this was an accident, or if your defense is that, no, I didn't do it, or there's some other explanation to this, then it's going to be very hurtful to their case, and it's very prejudicial against the defendant. So that's when it comes to homicide. But what about when it's just listed as undetermined? So if it's undetermined, there, Elizabeth Little had a pretty strong, I think, a very compelling argument that it should come in that the manner of death was undetermined. And that doesn't mean that this wasn't a homicide. It just means that just based on the examination by the medical examiner and the facts that the medical examiner found out about and the police investigation, that she was not able to determine the manner of death. So if she can't determine the manner of death, so then that's fine. And then you'll bring up some other evidence why you think the Commonwealth thinks that Karen Reed actually did it. So I do want to pull up one case for you guys to show you where this is Commonwealth versus Plunkett. And in this case, actually, take a look what this case says here. It says, we discussed briefly issues that may be raised at the retrial. A, the death certificate, if offered in evidence, this time should have the word homicide redacted or carefully explained. So it's not automatic that the manner of death should be removed from the death certificate. So a very strong argument, number one, is that there is no case that says that you have to remove the manner of death from the death certificate. It may be suggested, it may be recommended to remove it even when it says homicide. But if it's carefully explained, then this case says very clearly that it could come in. So this is also another argument why definitely when it comes to undetermined, it could also come in. So you definitely see some basis in the law where a manner of death could come in if it's just carefully explained. So that could actually help Elizabeth Little with her argument that you definitely see that it could come in as long as it's carefully explained. And that's, in this case, it's even talking about a homicide. So undetermined should also come in. So that can be another argument that she can make in terms of when it comes to manner of death. So let's move on to another area which I want to talk about, and that is Dr. Welcher. Okay, so we heard about the argument from Dr. Welcher, and that was what I want to focus on really today is the issue of his experiment. Now, I know that this is going to be a very interesting trial, definitely. I think it's going to be very different, like we spoke about. And Dr. Welcher, who is the Commonwealth's biomechanical engineer, did an experiment in which apparently he painted one arm one color and then the hand another color, and he's going to try to explain how this accident could have happened with Karen Reed backing her car into John O'Keefe's arm, and these injuries to his arm coming from the vehicle. Now, obviously, the first problem that we spoke about is the pattern recognition analysis, which was this is really this pattern on his arm. He's also going to try to opine, Dr. Welcher, that it's consistent with the pattern of the broken taillight. So that already was an argument that that's out of his expertise. To say that this pattern is similar to the pattern in from the taillight, that may be out of his expertise. But let's just talk about the experiment in general. Do experiments come into trial? And what I've spoken about previously is that experiments could come in. And even though it's an experiment that is done specifically for this trial, and this is a point that Alessi made, is that when you look at the Rentala case is the seminal case which talks about this experiment that's done, and whether you can admit these experiments into trial. Well, in Rentala, there was a lot of problems with that experiment. There was a paint expert, number one, whether there is such an expertise out there, a paint expert, and it wasn't just the issue that this experiment was created for this trial. Obviously, it's better if this is an experiment that you do every day in your line of work, and you can say, look, I do this experiment all the time, and now I'm just doing it again in this case, and that's why it should be admissible. That's one argument. But it's not dispositive. It doesn't have to be that this is an experiment that you do in your regular line of work, and then automatically, therefore, that's when it comes in. And if you don't do this experiment, then it cannot come in. That's not the only factor. If you look through the Rentala case, there was a lot of issues with that expert's proposed testimony about this experiment that he did. And when you have someone like Dr. Welcher, or when you have someone like Dr. Wolf, who did this experiment with the Canon, right? And right away, I'm sure everyone that was watching this hearing probably right away understood that, hey, we're talking about these experiments not coming in. Well, then how is the defense going to get the ARCA expert, Dr. Wolf, to talk about his Canon experiment? So what I see happening is that an experiment could come in as long as the experiment is done in a controlled environment. It uses expertise that it uses skills that you always rely on in your regular course of work. So then the experiments could come in, which is why most likely the Canon experiment is going to come in, as well as Dr. Welcher's experiment is going to come in. And it's not dispositive just by the fact that this experiment was created just for this specific trial. So that's that. If you have any questions, just if you don't mind, just putting them again in the chat, so I don't have to go all the way back now and look for some of the questions. I'll try to give you a minute or two to put some of the questions in, so I don't have to go all the way back and then end up behind and all the waiting that's going on. I don't want to keep anybody here longer than you have to be. But that's with the manner of death and Dr. Welcher. So there's another issue that came up, and that was with the police investigation. Remember, Alan Jackson wants to bring in this Easter guy, Michael Easter, and he's some FBI expert, investigative expert, and he's going to talk about how inadequate this police investigation was. So he's going to talk about that, and that's what he wants him to talk about. And the question is whether they're allowed to bring in this type of expert. So that was brought up. And then what was interesting is that Hank Brennan said, well, what are we supposed to do? Are we supposed to now get our own expert to say that this expert that the investigation was perfect? And Alan Jackson's response was, yeah, go ahead, do it. That's exactly what we want you to do. Go get some expert here and say how this investigation using solo cups and one stop, what was it called? These bags is the way to conduct an investigation. Go ahead, do it. And that's exactly what rebuttal is for. That's what you do in trial, right? We put on our witnesses. You want to rebut our witnesses? Go ahead, get a police investigator who's going to testify how perfect this investigation was. Okay, so it's that's what trial's all about. So go ahead and do it. Okay, so I see some questions coming in. Let me see if I can get them here. Okay, Lynn, why did Brennan mention the Bowden defense and law enforcement contravents in his motion as a reason to get access to the communications? So the reason why he wanted to bring in, just trying to remind myself, he was trying to bring in these communications between Karen Reed, number one, really to show consciousness of guilt. That's really his main focus here, to show that these communications are consciousness of guilt, that she really admitted to maybe hitting John O'Keefe. In terms of the Bowden defense, that would also work against the Bowden defense, because if your argument here is that the police didn't do the investigation properly, and here you are admitting that actually they did the investigation properly because you're the one that hit him and you're agreeing to that and you're admitting to that, well, then that's going to go contrary to your Bowden defense. So that's another reason why he's arguing that he should get these communications. Just Joe, wasn't Hank supposed to give notice to Karen Reed team rehearing? I'm not sure which hearing you're talking about. And so I can't, are you talking about the hearing coming up on Tuesday, or talking about the hearing? I'm not exactly sure what you mean here. So I have to pass on that question for now. Here's a question that I get almost every single live stream I do. Thoughts on Judge Cannoni's partiality? So as I've said, up until the Crosby order, I thought that her orders and her rulings were not necessarily biased, although the Crosby order really caused me pause, where she's allowing Crosby in without any sort of Daubert hearing, or excluding him outright. So that was really the one that's I'm struggling with. But I know that a lot of people feel Judge Cannoni's biased against the defense. So like I said, I look at the rulings. I don't really look so much at how she talks to them and her mannerisms. I don't really look so much to that. I look more to her actual rulings. And I've seen the rulings that could have gone against the defense in certain ways, and she hasn't. Take the motion to have Alan Jackson thrown off the case, to revoke the pro hoc vice. No sanction has been issued in that, as I said here today. That's definitely could have been something that she could have sanctioned the defense against. The misrepresentations that she found were material, repetitive, deliberate, intentional, and she didn't sanction them. So, I mean, you can definitely point to some of the orders that go against the defense and say, oh, she's biased. But you also see some of the orders that she could have gone against the defense and she didn't. So I'm not coming out directly still, but I do struggle with the Crosby order. That's one order that I really struggle with, and I don't have a good rationale. I can't understand why she would not at least order a Daubert hearing in that for Crosby. So that's one where I'm scratching my head about. So let's move on. Here's a question. Is it routine to hire a practicing defense attorney as a special prosecutor? Thanks. Actually, yes. This is pretty common because a lot of times, I mentioned this before, and this is what I believe. I know that people disagree with me, but I'm going to tell you what I think is that the reason why they went out to hire Hank Brennan is because he's just better. I think he's just better than any of the attorneys that they have in the DA's office. And they probably want a little bit of distance anyway. But I think we're seeing right away that he has a very different approach than Lally. And a lot of times when you are in the DA's office, when you're working for the prosecutor's office, the cases that you have are much more cut and dry. They're not as complicated. They don't have as many things moving. You don't have to use as much skill when, for example, in this case, there's a lot of issues that you have to overcome when you're in the Commonwealth. So they really need someone who's used to kind of working uphill, battling uphill, which a lot of times the defense attorneys are. And they have to get a lot more novel, and they have to figure out how to defend a case where they have a lot of things against them. So they kind of need a defense attorney who's more used to that type of posture, because this is a case where you definitely have a lot of facts that don't help the Commonwealth. And I would definitely venture to say that this is not your cut and dry case that a regular, prosecutor deals with. And therefore, I think they went out to get a defense attorney. So you found this with the Alec Baldwin case and Hannah Gutierrez-Reed. They got Carrie Morrissey, who does defense and also is a civil attorney also on the side with civil rights. So you do find this quite often, and very often defense attorneys can have a little bit more experience with dealing with a case that has so many different moving parts and so many things that you have to overcome, and you really have to, your whole approach has to be a little bit different than you're not generally used to when you're working at the prosecutor's office or the DA's office. Stop and shop bag. I'm sorry. Stop and shop bag. Leaf blowers. Yeah. That was some of the issues with the investigation. Here's a question. Can you opine on the defense naming Colin Albert, Brian Albert, and Brian Higgins as third-party culprits? So, like I said, we spoke about the third-party culprits, and that was the issue with the third-party culprits is that, just to be very clear, that you need to, if you want to use a third-party culprit defense, so you don't have to identify any specific individual. So that's something that Hank Brennan acknowledged in his argument. You don't have to specifically acknowledge any specific third-party person. But you could, at some point, request that there should be an array of people that you're talking about. And because the problem with the third-party culprit is that you have to also provide evidence. You have to provide relevant evidence, even though you could use hearsay. By the way, you could use some hearsay to show that certain other people were involved with this murder. You could do that. So in order to do that, you have to identify certain individuals. So the defense did have to identify an array of individuals, which is what they did here. Colin Albert, Brian Higgins, they all have ties, they all have opportunity, and they all have motive. So this is what you have to argue. You have to bring some sort of evidence that they had opportunity, they were close in time, close in place, they had motive. You have to bring some sort of relevant evidence, and it can't be too speculative. So that's what happened at sidebar. If you noticed that there was a sidebar conversation about what connections these three people have. So they did have to bring in these three people. I think that these three people you could connect definitely with being there in time, being there in the same place, perhaps having a motive. I think it's a stronger motive perhaps for Brian Higgins or maybe Brian Albert, more so maybe than Colin Albert. But as long as there's relevant evidence that can connect these people to the murder, and it's not too speculative, so then you can argue it as a third-party culprit. Now, what Judge Canoni did at last trial, which she's probably going to do at this trial also, I think she said that she's going to do this at this trial, is just not allow them to open on it. And if they are able to show some evidence that these people could have been the people that committed the murder, well, then they will be able to argue that to the jury and perhaps get a third jury instruction about that. So I think it's reasonable that they did mention these people. I think that they have to. You have to probably narrow it down to a certain number of people, and then you have to provide evidence that there's some sort of connection with these people. So that, I think, is all fine and dandy. Honey Bunny was having Rule 17 motion in front of a different court and under different case number than he filed without notifying defense Karen Reed sanctionable. No, I don't think it's sanctionable because that's the process. That's the procedure. In order, if you wanted, again, his case was with Turtle Boy, and he wanted to get the communications that was in that case between Turtle Boy and Karen Reed. So he could have done it in his case, but he could also do it in Turtle Boy's case. So I don't think that there's anything sanctionable about what he did. Here's a question. Hi, Martin. Late night watching from Western Australia. Have you read Mark Bettero's latest letter addressed to DA Morrissey, noting conflict and corruption and asking to recuse? Thoughts? No, I haven't read the letter yet. So I guess someone's going to have to email me that letter and I'll take a look at it. But I can imagine what it says. But I was not able to see the entire letter yet. All right, let's get to the bottom and then we'll move on a little bit more. There are a few other points that I want to talk about. We'll get to, hopefully. Just want to see if there's any other questions here. Here's a question, Leslie's vocabulary. I guess you like Leslie's vocabulary, which I do also. If Judge Cannoni allows Brennan's motion to get Yannetti's communications, can he appeal this? Yeah, sure, he can appeal it. They can appeal any ruling in this case that they feel is wrong as a basis for appeal. And definitely if they're going to be using those communications in the case, definitely that can absolutely add to the appeal as well as the appeal with the Crosby issue. I mean, if Crosby ends up testifying, I think that's a very strong appealable issue right there. But they're going to have a list by the time that this trial is over, all the different appealable issues that they feel that they have. But yeah, this can definitely go into one of the issues that they'll appeal. Here's a question by Mary. BC, can two things be true? John went inside, got punched, went back out as Karen was starting to drive off. He wings the glass at the car to stop her, but she doesn't see him, hits him, he falls. And I guess she hits him going forward, going backward. Not exactly sure how that would all work out, but the point is that sure, this can be true. I mean, anything can be true. I mean, that's kind of what Dr. Rentschler said. The possibilities here are endless. There can be all types of possibilities that happen. The problem here is that, I mean, I shouldn't say the problem here, but the Commonwealth has to prove what happened in this case. They're the ones that have the burden of proving their theory. So can this happen? Sure, maybe that happened. Can anything, maybe, did she hit him in any sort of way that the Commonwealth is not alleging? Sure, that's possible. It's possible. Maybe she killed him by drugging him. Like okay, talk about the toxicology reports, but there's the possibilities, as Dr. Munchel said, could be endless, and that's something that helps the defense because the Commonwealth has to prove their theory in this case. So. I love the Yannetti opening in trial one. Who do you think is doing 2.0 given team admitted won't be Yannetti? I think that was interesting, by the way, that Yannetti said he's not doing the opening statement. And this really leaves a lot of room for us to speculate who is going to actually do the opening statement. So I guess we can assume that it's going to be either Alessi or Jackson. I don't think Elizabeth Little is going to do the opening statement. From what I'm seeing in this trial, it seems that Elizabeth Little is much more in charge of the writing and much more in charge of the research. Of course, she's involved with everything, but every division of labor, you do very often have someone who's really good at research, really good at writing. In my cases, it's just me. So I'm really handling everything on the case. I'll get a little bit of help here and there, but it's mostly me doing everything. But when you have a big case like this, and I have been involved in cases with other attorneys also, where the divisions of labor will be, one person is going to be doing much more of the research and the writing, and maybe they'll do, they'll cross-examine a witness here or there, like Elizabeth Little did, like, a simple cross-examination, something like that. But the more complicated cross-examinations like Proctor or Jennifer McCabe, that's usually done by, the trial attorney. So, for example, my brother, who does a lot of trials, he is the trial attorney. So he's on his feet. He's doing the cross-examination. He's doing the opening and the closing arguments. And for the most part, he's got someone else who's doing most of the research. And of course, they're all working together. But you have someone who's with that type of expertise, who's really good at research, really good at writing, so that it makes more sense for that person to actually do that. So who's going to actually do the opening statement? It's going to be probably Alessi or Jackson. And it's going to be very interesting. I mean, I wonder if Jackson's going to do both. I think a lot of people like Alessi. I think maybe they feel that he's going to be more likable by the jury, perhaps, or not even say more likable, but likable by a jury. And maybe he'll be the one to do the opening statement, and Jackson will do the closing argument. Who knows? Who knows? I guess it's all speculation at this point, but I can see they're all capable of doing opening and closing arguments. So see what happens there. Here's a question. How do Karen Reed's lawyers reconcile JOK getting into a fight to the death with 3 men and a dog without any of their DNA being found under his nails or anywhere on his body? So that's a good point. So let's just talk about that. So number one is that, remember, the defense doesn't have to prove their case. The defense doesn't have to prove, that that's what happened. The defense just has to prove that there's reasonable doubt that it could be that happened. And when you have the argument that the police investigation was inadequate, and maybe they should have done some more swabbing, or maybe they should have done some more research about exactly how this could have happened, and they didn't. They chose not to because they didn't go into the house. They didn't do any research in that. They didn't do any searching of the house, and some other in police investigation issues, which are or leads that were not followed or whatever. So then there can be definitely some arguments about that. Talking about the dog DNA, this is a big point on the other side that feels that Karen Reed is guilty, and that is that there's no dog DNA, and we know that there was some pig DNA, but the dog DNA, the basic argument there goes is that his clothing was sitting in the snow for a long time, and then it was in the police in the police evidence room, whatever it is, for 3 months before it got sent to any lab. Who knows what sort of contamination could have happened there? That's in terms of the dog, the dog bite. Now, the other part is that, a lot of people are talking about the fact that, especially that they're going to have this neurologist who's going to testify that this blunt force trauma to the back of his head, to the back of John O'Keefe's head, could have only happened through a fall, right? And not being punched, not being hit with a baseball bat, that the only way that could have happened is through him, falling backwards. So if you can just speculate for a minute that, let's say, for example, he went into the house and he was pushed down the stairs, and there wasn't so much of a struggle. It was just everyone's drunk, they're uneasy on their feet, unsteady on their feet, and perhaps he was pushed backwards down the stairs, smashed his head on the bottom stairs. Is that a possibility? And then that's what knocked him out without any sort of struggle. So could that have happened? Why not? I mean, that's a possibility without any sort of struggle or DNA under his fingernails, anything like that. But again, I think that all of this is just, a lot of it's speculation. But the point here is that the defense doesn't have to prove their case, and it's on the Commonwealth to prove their case. So that's, I guess, my thoughts on that. Let's pull up some more here. Okay, we got Martha Chapman. Thank you very much. Could the defense request flipping trial seating such that O'Keefe's family is behind the defense table and Reed's family is to her left, solves problems of Karen dramatically turning back to the father and Paul, father and Paul O'Keefe creepy staring? I was actually thinking about this myself. Generally speaking, you sit by your side. Now, in Massachusetts, again, another odd thing about their courtroom is that the prosecution sits in front of the defense. Most courtrooms that I've been in, you have two sides. You have the defense on one side, and you have the Commonwealth on the other side, the prosecutor on the other side. And usually the people that are supporting the Commonwealth, the victim's family, they're all behind the prosecutor's table. And you have on the other side, you have the defense's all their family and their supporters behind the defense. So that's kind of how they sat in this way. And then they just, I guess, put the O'Keefe family, I guess, on the side, kind of closer to the prosecution, but it's just not. It's the configuration is just a little odd in this courtroom, in which you have the prosecutors in front of the defense, which is just it's a little bit odd. Again, another thing that's odd in Massachusetts. But this could be an easy remedy. I mean, Judge Canone can do this. Maybe Karen Reed won't feel comfortable having all of the victims' families behind her. Maybe you can make an argument about that. But if you're trying to avoid them staring at the jury, maybe you can do that. But again, even when you're sitting behind Karen Reed's table, she can still be, they can still be looking at the jury and staring at them. It's not a direct stare, but it can still be a stare. So the defense is first moving to get them completely excluded from the courtroom. I mean, so that's, whether that's going to happen or not, it's probably not going to happen, but this might be a good idea. This might be a way that you can work around that. Wristband ruler, $5. Thank you for that. I'm tuning in late. Do you feel like Brennan pronouncing Alessi's name incorrectly is purposeful? It's funny because somebody, when I was reading one of the Brennan's motions, I think this last video when he was asking for the communications between David Yannetti and Karen Reed. So when I was reading it, I don't read the entire motion. Usually I try not to do that. Maybe I did, but I don't like to do that. But some people commented that they just hear Hank Brennan's voice, even though I'm reading it, but they still hear his voice when he's writing it, which kind of suggests that he's actually writing these motions because that's how he talks in court. Do I think he's pronouncing Leslie's name incorrectly? But I don't think he's doing it purposefully. And the way that he says Kearney, Aiden Kearney, he didn't say Carney. Is that purposeful? I don't think it's purposeful. But here's the Rad 99, $9. Thank you very much for that. And we got here to Truth for Liberty, $5. Peer accepted reliability methodology equals expert ears. The crime scene spoke to me. Yeah, that may be a peer accepted reliable methodology, right? It's got to be accepted by the scientific community. So, when the crime scene speaks to you, you got to find some papers out there that support that. But okay, let's kind of move on a little bit more. I'm going to try to get to the bottom because I'm getting really behind here. I appreciate everybody showing up today, even though it's a Sunday. So I appreciate that. But I'm really, really behind. So I'm going to try to get to the bottom. Okay, I want to move on to something else, and that is which is a very interesting issue also, which is the niece's communications with John O'Keefe. So the niece, I'm not sure what her name is, testified in last trial, which we were not able to see or hear. And apparently she testified about some communications that were made between John O'Keefe, or that she talked to John O'Keefe about, and it had to do with the relationship between Karen Reed and John O'Keefe, right? So, so the question is, are those statements admissible? And I think that this is a very interesting issue. It actually also very similarly came up in Donna Adelson's case, where so you have to start from hearsay, right? So you have to start from hearsay. That hearsay is generally not admissible. So you can't just admit an out-of-court statement by somebody who's just going to say something that she said over to John O'Keefe, or that Karen Reed told her, or that John O'Keefe told her, or John O'Keefe told her. So how do you get these statements in? So the only way to get these statements in is to be able to show that it's not being offered for the truth of the matter asserted. So what other purpose would these statements come in for? So one very basic exception, which is always cited by both defense and Commonwealth, is that it's to show state of mind. These are not statements that are being offered for the truth that John O'Keefe's relationship with Karen Reed was at the end, but it was just to show that Karen Reed felt that way, and that's why she murdered him. So it's just to kind of show state of mind. And again, the issue with that is the following: is that number one is that Karen Reed had to have known about these statements. If she didn't know anything about what John O'Keefe told the niece, Well, then how is that going to show that this had any effect on her, right? Like an effect on the listener. How is it supposed to have any effect on her if she doesn't know that John O'Keefe made these statements to the niece? So you have to show that these statements that John O'Keefe made to his niece was actually known to Karen Reed. That's step number one, which is a very important step that they have to show. Step number two is that even if Karen Reed heard about these statements that were made from John O'Keefe to the niece, these have to be statements that would be likely for her to act in this type of way. So if it's just a statement about how, Karen Reed burnt my dinner last night. Well, is that something that's going to throw somebody into a rage and murder their boyfriend? So the 2 points that Alan Jackson made about this, which I think are very strong points, is that number one, the Commonwealth, if they want to introduce these statements that the niece is going to say that John O'Keefe told her, it has to be proven that Karen Reed knew about these statements. And number two is that these statements were of the kind and character and nature that it would throw somebody into some sort of a rage. And then you can bring then you can have an argument that these statements come in and they're not excluded because of hearsay. So until the Commonwealth does that, Alan Jackson has a pretty strong argument, I think. So that's just in terms of that. Let me see what else we have here. Thank you very much, Deb. I really appreciate you finding case law and providing such good counsel, which I think are helpful to the team. Well, if the team's following, then maybe they find this helpful. Otherwise, I definitely enjoy doing this for all of you because it's important to do some of the research and see what the case law actually says about some of these things. I know that, you can just read the motion and talk about your casual experience and what your knowledge is generally about this. But if you actually go and do the hard work and do the research, you can actually show a lot more about whether this motion has any sort of basis or not, or any support. So I enjoy doing that. I like doing that. It's one of the things that I like to do, some of the research. So I'm glad that you appreciate it. Just one more thank you from Natalie. Thank you for your impeccable coverage. Appreciate that. Let's see if we can get to any more questions here before we move on to one other issue here. Did everybody see the juror questionnaire? Everybody see that juror questionnaire come out? Anybody have any questions about the juror questionnaire? Because I like to pull it up and some of the questions that I saw interesting. So let's pull that up. Here's some of the questionnaire. But before we do, let me just pull up this. Thank you very much for the $5. Thank you so much, Martin. Great points. Appreciate that. All right, take a look at this juror questionnaire for a minute. So they go through a number of different questions here. This is a juror questionnaire. Is there anything about this case? They go through some of the basic allegations. Is there anything about the basic facts of this case that would make you difficult to serve as a juror? And then it gets down to this. Take a look at this. Would you automatically believe or disbelieve law enforcement officers, firefighters, or fire responders simply because of their occupation? Now, this is an important question because a lot of times people will automatically feel that police officers are more believable. And this is definitely something that I've seen a lot. I know this is something that my brother, who does a lot of civil rights work, he always has to make it very clear with the jurors before he starts with the trial that you don't automatically believe police officers, because if you go with the same speculation or the same doubt about a police officer saying the truth as opposed to as anybody else, so then that's a good starting point. But if people kind of believe police officers just a little bit more easily than they will other people, well then from in this case you're going to be working from behind. So this is a good question, and also, which is why it would be to have some good follow-up by the attorneys asking these questions. And we know that the attorneys are not going to be able to ask questions. And let me tell you why. Okay, so when you have these type of jury selection, you have a jury selection of a very important case, and it has to do with these type of questions like police officers. Do you believe police officers? So if you ask it in this type of way, would you automatically believe or disbelieve law enforcement officers? I think most people are going to say no. Right? Yeah, but I don't automatically believe police officers. Of course, I'm going to give everything's going to run through the same analysis in my head, whether the person is a police officer or not. Right? That's the general answer. I think most people are going to answer that no, they're not going to automatically believe police officers. But here's where it's very helpful to be able to actually talk to the jury and actually follow up on these type of questions, because what you can do is you can set up the stage the following. You can say, you know, Mr. Smith, I understand that you've answered this question that you're not going to automatically believe a police officer. But let me just ask you this question: do you slightly lean towards believing officers? You know, not just completely believe them outright. And of course, you're going to, you know, be a little sensitive that maybe they're not saying the truth 100%. But do they start off a little bit more ahead than an average person? Do you think that they're just a little bit more believable, you know, just a little bit more, because, you know, after all, they are protecting us, and they're police officers and they're sworn and they take an oath, and, you know, they've done such good community service and they have a record of doing community service, and, you know, they help us out, and they come to respond to our calls when we need them. Do they just maybe start off just a little bit more ahead than a regular average person? And that's a question where you find a lot of times where the jurors will say, yeah, well, yeah, I guess I would give them a little bit more credibility. And then once you open up that door, then you can explore that door a little bit more. Well, how much more credibility would you say? Like, let's say we have a witness that says, you know, that this crime, you know, the person was not entering the person's house, and the police officer said that there was, and that's all you have in front of you. Would you just kind of a little bit more believe the police officer just by the fact that he is a police officer? So that's where it gets to where you really, it's important to see, and as an attorney, to be able to explore these type of areas, even though generally speaking, yeah, everyone's going to say that, no, not going to automatically believe a police officer. But if they just start off a little bit more ahead, they just start off a little bit more credible than your witnesses, it's good to flesh that out. And then once they're able to say that, then you can say, Your Honor, you know, he should be stricken from cause, and you don't have to wait a preemptory challenge. You waste a preemptory challenge on this person because, you know, he did at the end of the day state that the police officers do start off a little bit more credible in his mind than everybody else. And you can make an argument like that to the judge. But again, this is something that Judge Cannoni is not going to allow, it seems like. And this is something where your actual interaction with the jurors can actually bring out different answers than just a regular juror questionnaire. So that's something that again, like, we're not going to see in this case, and they're not going to have in this case, not going to have the benefit of. But that's why it's so important, because a lot of people could be holding these very slight biases that they're not willing to answer these type of questions in the affirmative of, but they will if you do a little bit more exploring to answer those type of questions. All right, let's move on. Here's another interesting question. Do you have any strong personal beliefs, or have you been exposed to any strong personal beliefs from friends and relatives about law enforcement officers, prosecutors, or the government? So that's, again, you know, very similar about their personal beliefs about law enforcement officers. Also would include, do you have any friends or family who are police officers? What do you feel about their jobs? And have they spoken to you about cases? You know, what type of things have they spoken to you about it? You know, when they talk about, you know, these type of investigations, what do you hear about those type of things? But again, these are things that are not going to get much follow-up, most likely. And these type of questions, Judge Cannoni is probably not going to allow. Have you ever been involved in a group, community, or individual activity showing support for law enforcement or outside your own community? You know, maybe you have gatherings or showings of supporting your police officers. There's nothing wrong with that, by the way. There's absolutely nothing wrong. You can answer this question yes, and you can still be competent to serve as a juror on this jury. But it's something important to know. If you're someone who's very active in supporting your law enforcement in your community, then you may just have a certain bend towards them. And then again, if you'd be able to explore a little bit more about that, you know, then it would be able to maybe show a little bit more bias, and then you'd be able to move to strike for cause. Have you ever been involved in a group, community, or individual activity that was critical of the police or law enforcement in or outside of your community? So, you know, you have it both ways. Some people are very critical, and they always look very critical on police. So that's something for the Commonwealth. The Commonwealth wants to know about that stuff. So these are interesting questions, but I think that really these are questions that should be really fleshed out, and really there should be a lot of follow-up. But unfortunately, I don't think there's going to be too much follow-up on some of these questions, which could really go against Karen Reed. Let's move up. Another question. Have you ever tried a case where 0 cops recorded witness interviews? If not, have you ever heard of that happening? I didn't word it the greatest. Hope that makes sense. So are there sometimes cases where the police will say, yeah, I spoke to this person, I just forgot to put in my report? Yeah, police always forget to put certain things in the report. You know, so But yeah, I mean, that's one of the issues in this case. But what exactly was reported when and by who, and when the reports come out. Like, for example, this Lieutenant Tully report that was authored when Jennifer McCabe came into the police station, came in to meet with Lally before her testimony in the middle of a trial, added some more information, and that information didn't get added to the report until 20 days later. It wasn't turned over to the defense till later. So, I mean, do you find police officers doing these type of things where, yeah, sure. Here's a rad. Can we all just finally admit once and for all that this judge is either helplessly incompetent or unabashedly corrupt? Can there even be a third option at this point? Okay, well, I think a lot of people agree with you, the rad 99. So you're not alone with thinking that. Truly enjoyed your unbiased deaf tutelage. Well, thank you for that. Okay, so one final thing I really want to talk about. Let me just remove this. Yeah, one final thing I want to talk about, and I'll see if there's any more questions, is the internal affairs investigation. So, we have the internal affairs investigation, and before we move into that, I see just got another one here from Martin. I'm a legal content creator based in Boston that just started covering the case. My peeps love you. Can I interview you? 61K channel. Absolutely. Just send me an email, brothercounsel99@gmail.com, and we'll set it up. So I'm happy to talk about this case. Great from Boston. So happy to do that. I'm glad that they like me too. Not going to go against that. Okay, one more thing is that this internal affairs investigation, right? So this internal affairs investigation and these conclusions and the findings. This is an interesting area. We did a video about this, about whether these type of internal affairs and conclusions or findings are going to be admissible in this case. And I just want to say, it's generally speaking, it's bad acts, character testimony, those type of things are generally, it's hard to get those things in. But I did show you that there are some cases which do allow internal affairs investigations and findings and conclusions, in my view, that they could come in, when the case warrants it. And specifically in this specific case, I think one of the most important factors why the conclusions and findings would come in, even though Hank Brennan did say that he doesn't believe that the conclusions come in. And this was not a motion that was argued, by the way, in the last hearing, because when Hank Brennan filed this motion, it was before the conclusions were made, before the findings. So there's two reasons why the reports come in. Is that even though the bad acts argument and the bad character shouldn't come in because of character testimony, and that usually doesn't come in, but you could show bias if you have certain actions that were taken by a police officer which show bias. So bias and prejudice evidence does come in. It's a different rule, and it's not considered just regular character testimony or bad acts testimony, which would come in, which doesn't come in. So, and we showed you in that finding that the findings show that there was an appearance of bias, that there was an appearance of prejudice and bias that Proctor had going into this case. So, number one, that finding should be able to come in because that's just showing bias and prejudice, and that we're not just making it up. This is actually a finding of bias, or proposed bias, or the appearance of bias. So that's number one. Number two is that usually, generally speaking, these internal affairs investigations, which they're talking about, have nothing to do with the specific case at hand. They have to do with this police officer had an internal affairs investigation about a personal matter that he lied to the police station about. He said that he took off, I don't know, he took off vacation time or whatever when he wasn't supposed to, or he didn't. It's usually or it's activity that he did in a different case. So there's a little more difficult to get this stuff in. So, for example, the defense wants all of the reports about the Sandra Birchmar case, right? So they want those findings to come in, and that, okay, there you can make the argument, okay, that's a different case. So does that automatically come in? It's a different analysis. But here you have the actions of Proctor that were taken on this specific case. So I would argue that that's all part of this investigation. All of this is all part of the investigation. So there's much more of a stronger argument for this internal affairs investigation and the findings specifically to come in, because it has to do with this investigation on this case. And most of the other case law that I found that talk about this, it's about internal affairs investigations that have to do with other cases or personal matters. And then there's much more of a reason why that shouldn't come into this specific case, because it doesn't have anything to do with this case. Now, the Commonwealth can still argue that even though Proctor may have had the appearance of bias and prejudice in this case, it didn't affect the overwhelming evidence that they have against Karen Reed and all that stuff. They can certainly argue that, but in terms of it coming in, I think that there's a very strong argument that it should come in. So that's with that. Let me just put this up there from Martha. You are wonderful on Tom CPU. Loved hearing you talk about your father and brother. Help explain why you're so open to discussing new ideas. So I went on to Tom CPU, and that was a nice conversation that I had with him. Very sweet guy, I think. He asked me if I'd come on again. I'm sure I'd love to have another conversation with him also. He's a great guy. We had a very nice conversation. We spoke about most of the evidence. There were some things that he spoke about that I was not aware of, actually, because I as you know from this channel, I base solely almost everything that I talk about on the filings in this case and what I actually see in court. So there's a lot of other investigations and journalists that are doing other investigations out there that are looking into other things, and they're able to gather certain reports and things like that. And I don't like to to sway out there, because I really like to limit everything that I'm talking about and things that I can read, things that were filed, things that are subject to cross-examination, and things that I see in court that are mentioned by attorneys on the record. So that's usually what I limit my analysis to. But he had some other information also out there and he said that they're actually going to be, I guess, maybe bringing it up in this next trial. So until it actually comes up in this trial, I can't really have a educated opinion about it, but was some interesting things that he was talking about. So, but okay, I think that really covers mostly of what I want to cover. If there's any other questions, definitely put them in the chat now so I can take a look at them, and then we'll call it a Sunday morning, and we'll get to lunch maybe a little bit early. So let me just see what else we have here. By the way, Blessed Mom from Texas, Brother and Melanie would be great too. There were some communications I had with Melanie. We spoke a little bit about doing a show together, and the communications kind of went silent. So I don't know what's going on there. I did have a great conversation with Andrea Burkhart. That was a great conversation. I actually wanted her to come on with me again today on Sunday, but she was busy. So we're not going to be able to do it today, but we are still in the talks about doing some other collaboration, specifically with the Karen Reed case. I know she's covering a lot of the Brian Koberger stuff, and most likely once Karen Reed finishes, I'm going to be looking at the Brian Koberger stuff a lot more. There's just a limited amount of time. But let's bring up this here question right here. Not this one. Here we go. How do jury strikes work, Brother Counsel? Okay, so the way the jury strikes work is that each side has an unlimited amount of challenges for cause. So if there is a good cause why a juror cannot sit in the jury, if a juror gets up there and says, to be honest with you, I think Karen Reed is 100% guilty, and there's really very little that can change my opinion about that. So if she says that, or he says that, then that's a challenge for cause, and he can't be objective. He can't, or that person cannot serve as a juror. Or if a person gets up there and says, wearing all pink, saying, I am absolutely on the free Karen Reed side, and there's really very little that's going to be able to convince me otherwise, well, then that's a challenge for cause. So challenges for cause, you have an unlimited amount of time that you can challenge for cause. Preemptory challenges is challenges where the judge will say that there's no challenges for cause here, but each side can exercise a certain amount of preemptory challenges, which is just challenges that you can dismiss a juror just because you don't like the way that they look, or just because you don't like the way that they're looking at your client, or because the way that they answered some of the questions from the juror questionnaire, or questions that you were actually asking them, you just don't get a good feeling from them. Or maybe they've been a police officer for the past 30 years who claims that they're going to be completely objective, but you have your doubts in the back of your mind about whether you want that person serving as a juror. So then you can, on your own, you have a limited amount of time of challenges. I don't know how many they are in Massachusetts, and it wouldn't surprise me if it's a little bit different than every other jurisdiction, as we keep finding some more oddities about Massachusetts law. But yeah, there could be just challenges that your team will get together beforehand, or as the questions are going on. I always like to have another person there with jury selection so I can run my ideas off of them, and whether I like a certain person, don't like a certain person. There's actually one case that I had where there was one juror who I thought I just didn't like. I just thought that they answered all the questions fine, but I just got a feeling that this is a juror that's not going to be on my side. And I was talking to another attorney who I brought with me to help me out with jury selection. I was talking to him about my ideas, and that person actually completely disagreed with me. He said that this juror is going to be completely on my side, and he thought that I should not strike that juror. And I was limited to I did have some more preemptory challenges to use, but I went with his gut instead of my gut. And it turns out that after the end of the trial, I lost that trial, and it was a civil case. And I spoke to some of the jurors afterwards, and some of the jurors said, "Yeah, we really were all on your side, except that one juror. That juror really was trying to convince everybody that you shouldn't win, and they really convinced a few people, and that's why you lost." So it turns out that I was right. It's hard to tell. Sometimes you think you have a juror on your side, and they're not on your side, but that's how. Basically the challenges for cause go. You get an unlimited amount of challenges for cause, and preemptory challenges, you're limited to a certain amount, then you really have to use them wisely. And, there are certain jury consultants out there that will have their ways of deciding about whether a potential juror is going to be good for this specific case, for this specific demographic, for your specific client, so there's all types of books have been written on it and all this stuff. So there should be a lot of thought that go into it. I know that I've seen very lackadaisical attorneys that don't really care that much about jury selection, which I think is a mistake. But there should be a lot of thought that goes into picking a jury. Well, Cynthia 1880, thanks for joining the Brother Counsel Sidebar membership. Appreciate that. Here's a question, Marco. Brother Counsel, gun to head, guilty, hung jury, or not guilty? Well, I think it's a little bit silly at this point for me to say anything because I haven't seen the trial. I always like to see everything play out. And I think that the trial that we're going to be seeing in this next trial is going to be very different than the trial we saw in the first trial. Now, as you know, my opinion from the first trial is that she should have been acquitted. There's definitely not enough evidence to prove beyond a reasonable doubt that she actually committed this crime. As well as the juror confirming that when the juror Ronnie the juror did the interviews in which he said that essentially the jurors that felt that she was guilty completely discredited the ARCA experts, which is troubling. You don't want the jury to discredit people, these experts, when they're largely uncontradicted, and they didn't really cite any of the reasons that we keep hearing from the side that thinks that Karen Reed is guilty. They didn't say any of those reasons. It was just they just thought that, she must have done it because she was there and he was there and her car was there and there's a broken taillight. So I guess everything adds up when things didn't really add up. So that was last trial. But this next trial, I'd like to see how it plays out. I really want to see Dr. Welcher. I really want to see. That's going to be probably one of the most important parts for me. I really want to see Dr. Welcher testify. I really want to see how he's going to do on cross-examination. And I also want to see how the ARCA experts, if it was me, and, I'm sure that this is what the defense is doing. I'm sure that the defense is giving the entire report of Dr. Welcher over to the ARCA experts and saying, hey, does this guy know what he's talking about, or is he full of it? And if he's full of it, I want you to show on the stand that he's full of it. So, so that's something that I really want to see how Dr. Welcher explains how this accident, according to with using the Commonwealth's theory, actually happened. And then I'm going to save my judgment for after the trial. So that's always been my approach. Again, after the first trial, it was clear to me that she should have been found not guilty. But the second trial is a new trial, as we keep hearing Judge Cannoni and all the attorneys talk about. This is a new trial. It's a new trial, so we have to see how the evidence comes in. We have to see if anything changes, which I think there are going to be a lot of changes. And so I'm going to save my judgment until I finish seeing the entire trial. And then I'll tell you my opinion straight out. No problem. Liz Proctor-Carmel would love to see Brother Counsel and Lawyer No. So just so you should know, I did reach out to Lawyer No, sent him an email. I don't have any direct communication with him, but I did send him an email saying, hey, do you want to collaborate on some of this Karen Reed stuff? I think a lot of people would be interested in it. I know I've gotten a lot of requests to collaborate with Lawyer, so I did reach out to him, and if he responds, then we'll do that also. So I think he also seems to be very well read. He seems to know the law very well. I haven't seen a ton of his stuff, but the stuff that I have seen, he definitely seems to have a lot of experience, and I think it would be a very interesting conversation to have with him. So if anybody else can help make that happen, I would welcome it. But I did reach out to him, the email that he puts on his channel. So I sent him an email just letting him know people want us to see us together. Let's do it. But I haven't gotten a response yet. So. Let me just see if I have anything more here. Okay, here's a question. Can Judge Cannoni's findings of violations of candor to the court, although unsanctioned, be appealed to the Massachusetts Bar Association? Okay, so it's really a separate body. If Judge Cannoni could, and maybe she'll feel that she has a duty to report them to the bar, that is possible. So it's possible for her to report them to the Massachusetts State Bar, and even to the LA State Bar. Whatever, if she feels that they acted in that way, then they definitely could be reported, and that will be a separate hearing. It's not going to be an open court. These are separate hearings that are done. It's like administrative hearing, like internal affairs hearings, and then we'll see if there's any findings with that. But yeah, it's not the end of the issue by the fact that Judge Cannoni did not on her own revoke Alan Jackson's pro hoc vice. She had those findings. She made it clear on the record. And there could definitely be an argument that if she had those findings, then she actually has a duty to report them to the state bar. So there could still be action taken, disciplinary action taken on that. Let me see what else we have here. Here's a question. Would you be concerned about Judge Cannoni's condescending remarks toward the defense that it will hurt or affect the jury's opinion of the case? I feel like she will affect their view of the case. So this is something that you do find sometimes, where a judge will openly act hostile to another side. I've seen cases like this. I was actually in a trial once with my brother, who is lead counsel, and the judge was being openly hostile to him. The judge was objecting to questions when the prosecution wasn't objecting to questions. And the judge was openly against him. And this was you'd see different forms of this, but you don't always see it as blatantly. But I have seen things like that, and it can definitely be very, very damaging, and the jury sees it all. And there's a specific jury instruction, which I talk about sometimes, where the judge tells the jury that if you think I have an opinion about this case, you are to disregard it. And in fact, in that case, which my brother actually ended up winning that case, in that case, my brother actually pulled up that jury instruction to the jury and said, the judge just read you that if you think the judge has an opinion in this case, that you are to disregard it. And he said, I need you to do that in this case. And they actually came back and they found not guilty. So you do, but it can definitely be very hurtful. Yeah, absolutely. It can definitely affect the jury. And even though, like we talk about, it all comes down to the rulings. But if that's what the judge shows in the case, it can definitely have an effect on the jury. So hopefully that's not something that we will see in this case during the trial, at least. Here's a question. Do you expect Karen Reed's team to now move to have Dr. Rentschler be permitted to testify to injuries? I think yes. I think that could be a motion that they filed. I was a little surprised that they didn't file that motion. Maybe they still will, or maybe when they have the ARCA experts testifying, maybe they will move to have him be able to talk about causation. Because once Crosby can talk about causation, well, then why shouldn't Rentschler be able to talk about causation? So yeah, that definitely could happen. Just so everyone knows that Robert Alessi is here in the chat. But he is under a gag order, so he can't really talk too openly about this case. So I just want to let everybody know, but he is here joining us, obviously, because, of course he wants to know what Brother Counsel's opinions are. But Robert, you should really, call me directly if you really want to talk. But to let everybody know, I've had zero contact with the defense, no emails, no phone calls, no text messages, nothing going on there. The most that maybe is happening is that they may be following, or someone's following and letting them know what I'm thinking. So, okay. We are getting way behind here. So let's see if we can just finish this up. Maybe take another question or two and then move on. Okay. All right. Well, I guess that's going to be it for now. We did a nice hour and 40. I hope we answered a lot of questions that are out there. And there's going to be more questions as this goes on. So definitely keep it here, Brother Counsel. We are going to be watching this case very carefully. And anything that comes out, we'll be doing our analysis. We're going to be doing the research, and we are going to be doing, showing it all to you and doing our recaps like we always do. So thank you all for joining us today. It was a nice long Sunday morning. Hopefully everybody has a good week, and we will see you all, by the way, on Tuesday. Most likely I will be live streaming the Tuesday 11 a.m. hearing and giving you my real-time analysis with what's going on in the Karen Reed hearing that day. So that's going to be Tuesday. We'll see you all here Tuesday. And if not, then hopefully I'll be able to get a recap on whatever happens on Tuesday out. And if there's any research that has to be done, obviously I'll do that too. All right. Well, thank you all for joining again, and we will see you next time.